Hello, and welcome to this talk about bringing a claim for judicial review. I'm going to talk about abuse of the process in this talk. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. So the court will protect itself against the abuse of its procedure. It's got a duty to ensure that its process isn't abused, so that if a party or a legal representative or any other person acts in a way which is thought to be inappropriate, the court may make certain orders. So, for example, it can make an order to strike out a statement of case. It can make adverse costs orders against the party who's acting in an abusive way in terms of the process. In respect of legal representatives, it can order a legal representative to pay a party's costs. This is known as a wasted costs order. It can also refer a legal representative to a regulatory body for further sanctions. In the case of a party, it can, in the case of an abuse of its process, make a civil restraint order, which means that there are restrictions on that person's ability to bring further claims. When it's employing this type of protective order, it'll usually give the relevant party or legal representative or other person, a third party to the claim, the opportunity to make representations on whether such an order is appropriate. The kind of thing that brings into play this anti-abuse mechanism are, for example, the following things. Now, these are just examples, and the Administrative Court Guide is at pains to point out that these are just examples, but this will give you an idea of the sort of thing that will attract this kind of protective procedure by the court. So, acting in bad faith or with an improper purpose. Attempting to relitigate an issue which has already been decided. So you try and bring the issue before the court again because you weren't happy with the result first time round. That's an abuse of the process. Similarly, raising something that could and should have been litigated in earlier proceedings, in a subsequent set of proceedings, will be regarded as an abusive process, and you'll hear phrases like res judicata, which is Latin for something that's already been adjudicated, or issue estoppel. So in other words, that issue has been litigated or could have been litigated previously in an earlier set of proceedings, and therefore you are stopped, or estopped as the lawyers like to call it, from bringing subsequent proceedings. So that's an abusive process. Starting proceedings or applying for an order after an improper delay is also regarded as an abuse of the court's procedure and may attract one of those punitive orders. Something which a lot of litigants in person fall foul of is a persistent failure to comply with rules or orders of the court. Now that's regarded as an abusive process, and so therefore there's quite a strong motive for you to comply with orders that are made. Once again, I suggest that you put into your diary the deadlines for doing anything that needs to be done under the court rules. Another type of abusive process is starting your proceedings and knowingly starting your proceedings in the administrative court, which ought to have been issued in another court or tribunal. So this is when you start a claim which should have gone, let's say, to the county court or let's say the employment tribunal. You start your claim in the administrative court. The court is likely to strike out that claim as an abusive process. Finally, in this indicative list are proceedings which are frivolous, vexatious, harassing, or manifestly groundless. Now, frivolous has a technical meaning, as does vexatious, as does harassing. But you get some sense from the ordinary meaning of those words of the type of things which are going to be struck out. Things that have been brought for an improper motive in order to be vexatious or harassing to the public authority on the receiving end, or where the claim is manifestly groundless, so it is misconceived, if you like. So there is no prospect at all of it succeeding. Another area that the administrative court tries to protect is its communications with litigants. The general position is this, that the court office will generally communicate with you in person at the counter, or by telephone, or by email, or by post, as you'd expect. And it will also respond to communications if the communication requires a response. So that's the ordinary course of events. There is an exception, however. If a person's subject to a notification of restricted communication, then that normal procedure won't apply. So what is one of these notifications of restricted communication? Well, it's sent by the manager of the administrative court office when it's considered that the person who's subject to it has been communicating with the court office in a manner which is aggressive or intimidating or harassing. And another ground for imposing one of these notifications is where the person has been communicating in a manner which is persistent, time-consuming, and without proper purpose. So, in other words, vexatious or time-wasting. The notice of restricted communication will tell the person the form of communication in which they may communicate with the court office, and it will say that they are restricted to that manner of communication. What it also tells the person is that all other forms of communication will be ignored, and a response to the permitted form of communication will only be made if the communication itself raises a new issue that requires the response of the administrative court office. This notification, when it's sent, is sent in writing to the last known address for the person who is subject to the notification. Now, the person who's subject to the notification can request in writing at any time that the court office manager withdraws the notification of restricted communication. And it's a request that the court office manager does that as an exercise of discretion. If you find yourself in this position, when you make this request in writing, you must include the reasons for the request. And if you do that, then you will get a response in writing from the court office manager. Now, many people who are in this situation are unhappy about it and will want to complain. It's important to appreciate that the notification is made by the manager of the court office in their capacity as an employee of Her Majesty's Courts and Tribunals Service. So if you want to make a complaint, you're going to be making a complaint using the Courts and Tribunals Service's complaints policy, and you'll need to get hold of a copy of that. The court does have jurisdiction, it does have power to control its own proceedings. You'll sometimes hear this referred to as the inherent jurisdiction of the court to control its own proceedings. So inherent, it means you won't see it spelled out anywhere in the court rules. It means it's the unwritten power of the court to control what goes on in it. So what this means is that the court can also make a notification of restricted communication, but it can also rescind or vary one.